Hi, my name is Matt Marcellino. I'm an attorney here at Marcellino & Tyson, and this is Jennifer Moore. She's also an attorney here at Marcellino & Tyson. Today we're talking about another family law subject area, and that is absolute divorce. Ooh, we said it at the same time.
Same time.
So anyway, this is kind of one of the reasons why we do the podcast, I think, is to try to help with some of the basic questions or the frequent questions we get from folks that either come in on the phone or do a consultation. And absolute divorce is always one that seems to be at the top of the list as to maybe just a general misunderstanding as to what it is, right?
Yeah.
So, we thought maybe today we would do this to help explain that it is something unique and it is its own what's called cause of action. But if you want to explain a little bit about that might be helpful.
So what I tell my clients is the absolute divorce typically comes at the end of the process. Sometimes it ends up being the middle of the process, but it is truly just the legal unbinding of the marital ties. It doesn't typically have anything to do with alimony or property distribution. It doesn't have anything to do with custody or child support. It is just, how do I legally divorce you from this person so that you could go and remarry somebody else, even if we're in the midst of still dealing with property or spousal support or custody with your ex-spouse.
Right. Yeah, I think like some of the confusion, and it makes sense, right? Like we do this every day, so it doesn't make sense to us, but it does make sense if you don't do this every single day. Like you just hear the word divorce and it's this like general term where you think it just encompasses all things regarding your marriage.
Yeah.
So a lot of people come in and say like, I want my divorce to be now, and I want it to include equitable distribution and child custody and alimony, and it's all in this one tidy little package because it's the divorce of the marriage, the ending of the marriage, right? But that's really not it. It's, you have a lawsuit, the complaint has causes of action within that lawsuit. Sometimes it's just simply equitable distribution, child custody, child support, and alimony, right? And the reason for that might be because they can't file their absolute divorce complaint yet.
Yeah.
Why might that be?
So you can't file for an absolute divorce. You can't file a lawsuit for an absolute divorce or include it in your initial complaint unless you've been separated for at least a year. So 1 year and 1 day later from your date of separation, which is on a separate podcast, that's when you can file for absolute divorce. And I think a big misconception for most people is that you wait to address custody and child support and alimony and property distribution for a whole year. No, please don't. That makes our job so much harder. You want to address all of those issues right at date of separation, before date of separation even sometimes. I mean, I prefer to get a client who hasn't yet separated so I can manage the whole thing. And then we're waiting that year and a day to file the absolute divorce claim. And like I said, sometimes by the time that year rolls around, I have wrapped everything else up for my client and I haven't spoken to them in a couple of months, and I pop back up in their inbox and I say, hey, guess what? I can get you divorced now. Or sometimes, unfortunately, the case is still very much active and ongoing, and the divorce just becomes a timely thing, and I take care of that while I'm still working towards resolving property and spousal support and all those things.
Yeah, it's rare to see a complaint for absolute divorce in the same lawsuit for equitable distribution, custody, et cetera, right? Because of that 1 year process. And you're right, that's a really good point, is there is this misconception, as you put it, like do not wait until you're eligible to file your complaint. You don't have to. You can. You're free to do whatever you want, right? But should you? Probably not, right? Obviously, if you have questions about that, you should come and talk to us and get a consultation so we can tell you when might be the appropriate time. But you shouldn't be waiting 12 months in all likelihood to address child custody or equitable distribution or support, only because it does make it more difficult for your lawyers sometimes, but it also might very much make it more difficult for you.
Yes.
You're like living in this limbo for 12 months waiting to do something that you could have already begun.
Yes.
Right. And so that's something that I think is always a topic of conversation during our consultations when we're talking about divorce.
And then the process of absolute divorce, like what does that actually look like and how long does it take? There's a lot of drama in Mecklenburg County right now, specifically about how long it takes. Once you file your lawsuit, I used to tell people it takes about 8 to 12 weeks to wrap up. That is sadly no longer. It takes more than that, months to resolve. But there is a process. You have to wait 30 days after filing your complaint most of the time. you have to serve the other side first and then wait 30 days from service. And then you can ask the court to have a hearing on the absolute divorce. And then the court schedules those hearings for us. We are not able to choose a date. And that date for that hearing is, unfortunately, in Mecklenburg County, months away. It is December of 2024 as we sit here today, and I just got a notice of hearing for March 10th of 2025. So.
Yeah, and each county is different.
Sure.
So in Mecklenburg County, you don't actually go to what's called a live hearing. It's an informal process. You just submit paperwork. The judge reviews it in chambers, essentially, and stamps seal of approval, and you're done. Yes. But it does take a long time to do that in Mecklenburg County. Other counties, you have to go in person.
Some of them,
Some of them you do. Some of them are quicker than others. And, but what I've always, even before we got into e-filing and so forth, was I always told clients that they should anticipate if everything was filed timely, right? From date of separation and then filing timely, about 1 year and 1 day, file the complaint. 31 days later, roughly, file the motion for summary judgment and then get your notice of hearing, that you should still expect it to be anywhere between 14 to 15 months from date of separation.
Sure, yeah.
Right? So, but now, if we're filing timely, depending upon the county, it could be 18 months.
Yeah, 18 months, easy.
And that's a lot for them to swallow because they really want to move on,
right? But
they can't.
Yeah.
So.
But then I have plenty of clients who have moved on essentially while they wait on that absolute divorce because we've wrapped up everything else and we're able to, they're dating again or whatever, and then suddenly I get them divorced and it's more of a formality.
Yeah. And maybe another way to explain how absolute divorces are unrelated to the other causes. Now, they're all somehow connected, right? There's some overlap, right? But in general, absolute divorce has nothing to do with any of the other causes of action. Something to think about is what are the actual requirements of an absolute divorce in North Carolina?
True. We're a no-fault divorce state.
Right.
Yeah.
So what does that mean?
So that means you can get divorced for any reason, or the only reason is that you've been separated for more than 1 year. Mm-hmm. I don't care. The judge doesn't care how mean your spouse was to you because for the absolute divorce. The judge doesn't care if he or she wasted all your money or drank too much. There's no fault required to get divorced in the state of North Carolina. Yeah,
essentially the only requirements are that North Carolina has jurisdiction for you to file that lawsuit here in North Carolina, so you're a resident, have been for at least 6 months before you filed it, right? Roughly.
Right.
And that you've been separated for a year. That's literally it. It doesn't matter to your point, who's mean, who didn't do the dishes, who didn't mow the lawn, whatever it might be. It doesn't matter.
Yes.
So it's a very simple process, but it does get confused a lot with the other causes of action of being part of it. It's just not.
Yes.
Right.
And two, I think, cautionary pieces to this. We said that the absolute divorce doesn't have any impact on the other causes of action, but if you get divorced, if the judgment of divorce, which is, people call it the divorce decree, that's a typical name that we hear a lot, but what we call it is a judgment of divorce, the document, the court order divorcing you. If that goes in before you've either made your claims, filed a lawsuit for claims for alimony and equitable distribution, or resolved those in some binding fashion, then you're barred from making them. So sometimes if I am sitting across from a potential client who seems like they're definitely going to separate, but they're iffy on when and how they engage counsel, and I just feel like maybe I'm never going to see you again and you're going to try to do this on your own, I always try to say, no matter what else you take away from this hour today, please know that if you go and get yourself divorced before you've wrapped all this up in a legally binding way, or at least have your claims pending with the court, you're barred. And so I try to put a little bit of the fear of God into them. Yeah,
I mean, that's probably the biggest takeaway from any of our consults, right? For somebody that hasn't begun the divorce process yet,
right?
It is literally the most important thing we say, because if you are a dependent spouse, and we'll get into maybe spousal support or alimony in another podcast, right? But if you're a dependent spouse, you need that money from your significant other, right? If you get divorced before you do anything about seeking alimony, it's gone forever.
Right.
I mean, how detrimental would that be to your livelihood for the foreseeable future? It's a terrible, terrible outcome.
Yes.
And same with equitable distribution, right? You may need those assets. You may need parts of the IRA or the 401k
or
your
the house. Yes.
Right. And if you haven't done anything, they're gone. You can't file suit for that. Now, there's circumstances in the past where I've even advised people, mum's the word.
To take that
because
stance,
if my client has, let's say, all of the assets and none of the debts are all in his name, but my client seems to have her name is all over the assets. Right. I'd be like, don't say anything. Just get divorced.
Wait that year.
Yeah, wait that year, try to get divorced and see if the other side files a claim for ED to prevent that from happening. Because if they don't, that person is, the husband in this scenario is stuck with all the debt, and my client walks away with all the assets.
And you're the best lawyer ever.
I know.
Yeah.
Right? So that has only happened one time for me because it's something it's very unusual because every attorney, I'm sure, knows this.
Puts the fear of God into people in a couple.
Yeah, just how important it is, right? Yes. So although it's not connected once the litigation begins and you file all your actions, it's a very good point, and I'm glad you brought it up, is if you don't bring up, meaning if you don't seek alimony or equitable distribution through either pending lawsuit or go through a separation agreement, right? Before you get divorced, you're toast.
Right.
It's gone. And if that's something you needed, that's a very terrible outcome.
Very sad.
Yep.
And then the other cautionary thing is don't lose track of your ex-spouse. We just had a case where we had to track this woman down. They had been separated for years, like decades. And we found her in Jacksonville, Florida in jail. So that was a happy outcome because it was slightly easy to find her in that way, but it still took, a lot more money on our end, and we had to pay a PI and the whole thing. So anyway, keep track of your spouse and, divorce them timely because you don't want to have to keep track of them for decades.
That's right. Because if you can't serve them,
then you have to serve by publication. And that is a great other topic for a podcast one day.
Can't get divorced without serving the other party. You have to have notice, right?
Yes.
So if you don't know where they are,
it's going to be
it's going to take a long time because you have to go through a lot to get that service requirement.
All right. Noted.
Yep.
Service by publication, future podcast.
Right. Yeah.
All right.
We'll let Clay do that one.
Good idea.
Yeah.
Okay, well, thank you all for being here. Let us know, of course, if you have any questions, feel free to call us and look out for our next podcast.